You're welcome back. This is Newsfile. It's your most authoritative news analysis show. And here on Newsfile, we put Ghana first. Now, I'll read a couple of messages to you, and some of these came immediately after the ruling was delivered. And I have the permission of those who made them on social media to share. Now, Suleiman Brahima, you know him. Suleiman Brahima is with the Media Foundation for West Africa. He says, corruption remains the root cause of all our problems. Any government that condones corruption and fails to tackle the canker cannot be genuinely committed to the development of this country. Based on the tricks this government has played with us on the Woyome scandal, I am convinced that this government is not committed to fighting corruption. May God continue to bless Martin Amidu. A lot of praises showered on Martin Amidu right after the judgments the ruling came. And then there was this one. I need to read it in a certain order. This was what Manasseh Azore Awini shared. He says that you are a young Ghanaian. Your government has been in power for 8 years. The fund which the government has set aside to help the youth set up businesses is worth 10 million cedis. This amount is for the millions of young people who may be interested in this funding. But your government has fraudulently paid 51.2 million cedis to one individual and is not serious about retrieving the money, even after an individual went to court to secure judgment. You are here defending the government and attacking those who put pressure on the government to retrieve the money. What does your conscience tell you about this? And why do you think someone must hate your political party to be able to criticize this? I'll read about two more, and this one I'm reading from Professor Kweku Asare. He wrote quite a bit, but I should read just portions of an epistle he wrote. He, together with a teacher, a lecturer at the Gimpa School Faculty of Law, Justice Shram Sai, are of the belief that the ruling was so wrong, was against the constitutional jurisprudence of this country. And then he says that because by Article 88 of the Constitution, it is the Attorney General who has been given the exclusive powers and mandate to institute suits for either criminal or civil for the state. It is wrong to allow an individual like Martin Amidu to do what he is seeking to do. Then he says, it is important to understand that an Article 2 private Attorney General has no capacity to enforce a judgment against or for the government. This is why the Attorney General is a nominal defendant in Article 2 lawsuits to enforce the resulting judgment. Thus, while the putative violation of Article 181 made Amidu a proper plaintiff in the Article 2 case, the resulting judgment was for the government, who became the sole and proper judgment creditor entitled to enforce the judgment and requests the oral/documentary examination described above. Then he says that, I'll just read just a bit of his conclusion. And he says that the judge was wrong. And then he comes to say, in sum, how the government chooses to enforce the judgment, including exercising the option under the rules of civil procedure to examine Woyome, is a political question that presents no constitutional question or even justiciable issue for the court. It was fundamental error for the court to allow the examination and to empower Amidu to execute the judgment. I cannot, like the majority of the country, celebrate a ruling that allows judges to rewrite the country's constitution and rules of civil procedure in such a revolutionary way, and that converts the court into a theater of the absurd. Respectfully and regrettably, I dissent and call on the court to review the judgment. Then I read a last one. Justice Ram size is a whole article. I'll look at it later. Then I read a response to him by Kwame Akufu, a response to Professor Kwekwasari by Kwame Akufu, who is also a lawyer. He says that, may I please remind you of the famous line in the Tufo versus Attorney General case, which the judge also quoted, that the Constitution is a living organism, quote, the Constitution is a living organism capable of growth and development, unquote. Kweku Bako has referred to that. So he's reminding Kweku Azan of this. And he says, what is the court to do when the Attorney General adopts a withdrawn attitude towards the enforcement of orders which brings the administration of justice into disrepute? Is the doctrine of necessity applicable when the gatekeeper for the protection of our right goes to sleep? Article 88 is for the benefit of the citizenry. The Supreme Court did not diminish Article 88 by ordering an oral examination of Woyome by Martin Amidu. So this is where I bring you to appreciate what appears to be the general view among the populace about the laxity or Amidu's accusations and allegations of the fact that the Attorney General's department does not have what it takes because it is complicit somewhat. So, on all of those matters, it gives you the impression of how Ghanaians think. Can you zero in on the questions that are being asked? Why are you opposing Amidu in court?
Right.
Why were you opposing him? Mm-hmm.
Well, as I said, we opposed him on grounds of principle. The statement I made earlier that we are not a banana republic. In a banana republic, the law of the jungle applies. In a constitutional republic, the constitution is supreme. And any step that you are taking, including a step to recover monies for a state, must comply with the constitution. I still stand by the view that under Article 88 of the Constitution and Section 9 of the State Proceedings Act, it is only the Attorney General who is entitled by law to have taken action. Now, the view has been expressed that we have been laxed in our approach. We have delayed. Some have said that we are not even interested in collecting the money and so on. But as I've said, there's overwhelming documentation in the public domain, in the courts, of law, to show that this Attorney General has actively shown a credible commitment to the recovery of these monies.
Okay.
And so for anybody to take the view that we are laxed, we don't want to collect the money from Woyome and so on, it flies in the face of the public documentation,
okay,
which we made available to the court.
Now let's deal with this quick.
Yes.
Amidu still insists that the present Attorney General is complicit because of the role of her former firm,
yes,
in matters that involved Woyome.
Yes.
We have on this platform shown clearly that there were about 3 matters in her former firm.
Mm-hmm.
And in all those 3 matters, her firm was against Woyome and not for Woyome.
Yes.
And that even in those matters, she was not the one prosecuting those cases.
Yes.
It was her other partner, who is later Tony later. Yeah. Martin Amidu says, you cannot say you were representing Austro Invest and not Woyome, because the court said that this was jointly for Woyome and Austro Invest, unconstitutional payment to Woyome and Austro Invest. Mm-hmm. So she's still complicit. And then moves a step further to say that her firm's lawyer is also the lawyer for the president now.
Yes. So, well, it was the lawyer for the president in the presidential petition. As far as the lawyer for the president is concerned now, that should be the Attorney General. we advised the president in his official capacity. And I don't think that the president has instructed Tony later since the petition.
He did. When the Ford expedition matter came,
thanks for the correction. But something in all these things about the representation of later Brew of Woyome, you would remember distinctly that this was stated in paragraph 10 of Martin Amidu's affidavit in support of his application. And you remember that the judge did order, when I argued that under Order 20, Rule 8, the Martin Amidu's application did not meet the standard of proof. And the judge ordered that that paragraph should be expunged. Now, what is the legal implication of that? It means that it does not stand part of the public record. It also means that if Martin is still insisting, Ms. Amidu is still insisting that that is the state of affairs, then it means that his deposition was a lie, and that he himself lied under oath because he swore to the affidavit in support.
The paragraphs of his affidavit that were expunged were paragraphs 8 to 12. Paragraphs 8 to 12. So 8, 9, 10, 11, 12.
No, that is not so. Paragraph 10 was expunged. Paragraph 12 expunged. 13,
sorry, 10, 12, 13, 16, and 19.
And 19
right.
were all expunged.
Right.
Okay. If we had to take a serious view of this matter, right, it meant that Martin Amidu lied on oath. Because when you depose to an affidavit, you know that you are swearing to the veracity of what you have deposed to.
How can it mean that he lied? Because the judge said they are being expunged because they are scandalous. He says he himself was not even comfortable about some of those depositions.
Yes.
And that he did not disclose the source of the information.
Yes.
And that's the major reason they were expunged.
In fact, that was the argument that I made in court. If you look at Order 20, Rule 8, particularly Sub-Rule 2, it provides distinctly that if you depose to an affidavit on information and belief, you have to disclose the sources and the grounds. And Martin did none of that.
Yeah, so I'm only saying that you saying it means those depositions were lies.
Yes.
Cannot be correct. It was expunged because he did not disclose the source and they were scandalous.
But they had no factual basis for it. He had no factual basis for it, and that is why they were expunged.
Okay.
And for me, if something has no factual basis, it means it's a falsehood.
Yeah. Right.
Okay. So as far as the public record is concerned, he deposed to falsehoods that were expunged from the record. So I don't even want to dwell on whether or not the Attorney General's firm represented Woyome, because as a matter of public record, the court has said that is groundless, and therefore it is expunged from the public record.
Kweku has asked the question earlier last week.
Yes.
That in your affidavit, you said you were going to put him to strict proof. Why is it that when you went to the court, you abandoned your earlier attempt to put him to strict proof and then prayed the court to have those expunged?
No, to put him to strict proof
of those claims.
Oh, okay.
About the president,
our affidavit in opposition.
About the president having instructed the Attorney General because Woyome was intent to expose some people.
No, something as a lawyer, and I'm sure you have done this in court before, right? There are layers of argument. So you have your litigation strategy, and you go with that. Now, our litigation strategy was, if we did not succeed in getting him to expunge them on the basis of Order 20, Rule 8, then we'll request that he should be put in the dock for me to cross-examine him.
Okay.
That was, but when we made the argument, I saw from the response of the judge that request would not be necessary. So I abandoned that leg. But if you saw my court notes, I was going to say that if the judge did not grant us this, if he wasn't willing to grant us this, in the alternative, we are going to put him in the dock, and I will cross-examine him on each of those paragraphs.
Unfortunately, those dispositions remain intact in the court of public opinion.
Right. That's a different court. That's a different court.
Now, to our audience, can you repeat in a minute why recourse to paying into the Iyoko exhibit account instead of the Ministry of Finance or
I hope that we'll deal because there was another issue about the dates of our
I'm going in that order. So tell us about the exhibit, the exhibit account.
Can I add one thing? And why is dealing with it? What crime that exhibit in relation to what kind of crime?
Crime.
Because exhibit account, the impression I get is that it's an exhibit
for criminal purposes.
A purpose.
When a criminal matter is going on,
yes,
you
that's
want
an
to,
exhibit.
then you put it into the exhibit account.
So what case or what crime does the exhibit relate to in this case?
Because Woyome says he didn't want to pay there because it has nothing to do with crime.
Yes,
okay.
Yes. Okay. Something I think earlier on I tried to explain why we did this.
You mentioned that you didn't explain, so go ahead.
So I mentioned the fact that the EOCO works under the Attorney General. The Attorney General is the superintending minister for the Economic and Organized Crime Office.
But
all right.
There's no control over the EOC accounts. That's the extension.
We don't have control, formal control, but she can direct the executive director of EOCO
to prosecute cases, but not to keep the money in the account.
No,
it's a different thing.
It's an administrative matter. In fact,
I haven't seen anything in this act that empowers the.
Anything that makes it unlawful?
Sorry.
Okay, I'm sorry.
No. It's it's part of the legal education that you say you've learned some law. I mean, bits and pieces of law here. The point is that the exhibit account, you are right, is for monies that relate to economic crimes. All right. But we have used it for good purpose. Okay? Not in contravention of any law. There's no law that says that you can.
The good purpose. That's what I want to know.
Okay, the good purpose is that the exhibit account cannot be the subject matter of Ganashi proceedings. In other words, a court cannot order that the money standing in the exhibit account be paid to a third party who is a judgment creditor against the state. All right. So all the payments that the judgment, debts that we have recovered, including the RLG payments, for instance, have been paid into that account. Now, let me be very factual about this. Look, as we speak now, the Ministry of Finance gave the Attorney General 16 million Ghana cedis for purposes of the completion of Law House. Okay, the Law House is the Attorney General's office, which was started. I mean, the building was started by Nana Akufo-Addo, then Attorney General, and then it continued with subsequent Attorney General. It's just opposite the Law Courts complex. Okay, now no adjacent, not opposite. That money went into our own account. Okay, NDK Financial Services obtained judgment against the government, not the Attorney General, because we are nominal defendants. We're not, the actual defendants in this matter. We didn't. It was the Minister of Energy that breached a contract, and the people went to court. As we speak now, that money has been garnished because it is in the Attorney General's account.
If it was put in the court, if the money was paid to the court, could it have been garnished?
But that is where you are. I mean, Martin Amidu
so
is wrong.
Kweku has asked my next question, which Martin Amidu also asked you.
He's wrong because the court didn't order that the money be paid into court. All right, you know that if there's no order to search, for it to be paid into court, you cannot, as a lawyer, go and give it to the register, and the register will accept the check.
Sometimes we pay without an order of the court to pay into court.
Well, I have never in practice done it.
Okay.
I have never in practice
but we do. We pay into court even without an order.
More fundamentally, what fatal flaw is occasioned by paying the money into
so
local
now,
accounts?
having answered the reason you do that, now I want us to clear.
Yeah, but even as we speak,
there are small issues. I want us to address small issues.
The check has cleared. Okay, so as we speak now, the 4 million is locked in for the people of this country. It has cleared.
Right. Actually, there's information that I have found through my investigations that the said Access Bank account is not as if he had a lot of money sitting in there. He had a lot of money sitting in there. He had gone to put this money in there before he issued the check, and then the check was cleared. So it's not as if he had money in that account.
Interesting to find out where that money came from.
So the next question is that he brings this check to you, and you get to find that he has a bank which you should have proceeded against to get money, which you did not. The question being asked is that why have you not pursued that account? And this is how Isankuma puts it. He says, a guy who owes Ghana millions and is taking every conceivable step to avoid judgment being executed against him, finally writes you a check of 4 million. The first thing you do is to scrutinize the check. Number one, this is a check, not a bank draft. It means he has an account there. and is operating it on your blind side. 2, there is a bank stated. 3, there is a branch of the bank stated. 4, there is an account number stated. 5, the check number is 00008, suggesting that at the very least he has written 7 other checks before this, and that this is a brand new account. Dude has money, he exclaims. 6, the handwriting on the first line stating Iyoko as the beneficiary of the check is not the AG. It is different from the rest of the check. Not that it is fatal, but it is telling. Now, you now have every cause to move against this account to take whatever is in it. And you say you don't care about the source. And this is directly to you, because
yes.
you said
yes.
on the morning show with Kojo Yankson that you didn't care about the source.
Yes. And I still don't care about the source. And I know that if Esankuma were representing a client, and that client is owed money or was owed money, and then the client's lawyer agreed a payment plan with him, and the judgment debtor brought a check to him in good faith as lawyers. Okay, he will not immediately go to court and say, attach that account for me. He's not going to do that because he has in good faith agreed with the lawyer on the other side that there's going to be a payment plan. It is only when there's a default that it triggers the court process. And you can now say that, let's look at, Access Bank and issue a Ganashi order against Access Bank just in case that, there's money in it. This is the best practice and in the best interest and the best traditions of the law. This is how we have practiced the law. So for me, I will defend the practice and conventions at the bar, okay, and not say that just because there's public interest in finding out what is in that account, we would put aside.
Does it not matter that you are saying you don't want to break the professional code?
Yes.
And questions of morality and everything about this?
Yes.
Does it not matter that you are dealing with a client?
Yes.
You are dealing with someone, a debtor, who is doing everything to evade paying. He promised you he was going to pay within a certain year.
Yes.
He didn't pay a dime.
Yeah, but that was because we rejected the payment plan and we thought that it was going to take him too long to pay. We didn't agree with some of the terms of the payment plan, especially the timing. Not the timing, the time frame within which he was going to pay.
I see.
And that's how we rejected
now the
it.
final question to you, and which we also demand a brief one.
The proceeds of the Ganashi things, the proceeds, the earlier ones, the pottery, from where were they deposited? Were they paid into the exhibit account?
No. What happened was
why not?
That, no. Let me tell you why. Okay, because we have an account with the Bank of Ghana. Yes, and that is the account that has now been Ghanashied. Okay, that is the account that has now been Ghanashied. The 32. The 32.
So even that money you took in there, if you had not spent it, now it's been locked up. You can't have access.
Yes, I don't get it. You mean those proceeds you send them to Bank of Ghana?
Yes.
And somebody has Ghanashied them?
Yes.
Who? How?
NBK Financial Services.
Because you owe.
Because
we go after the accounts and ask how much is in it.
Yes.
You don't identify which money came in, whose money was it.
AG's account at Bank of Ghana.
Yes. All right.
But
so now
one small question.
Yes. If you can answer my last question.
Why are we still maintaining the demand at 51.2?
Okay, we'll come there. We'll come there.
Is there any good reason for that?
The questions of dates.
Yes.
When you went to court, that's one also an issue about your integrity as the Attorney General.
Yes.
That you say that Woyome had indicated an intention to pay.
Yes.
And that is why you discontinued the cross-examination.
Yes.
You had applied on the 12th of October. And then by the 19th, you had been granted to cross-examine him.
The order.
Right. Now, you go to the court, and then the document you prepare to the court has a date on it, 26. That's a date on which the Attorney General prepared the document.
Yes.
Yet, the date of the letter from Woyome to the Attorney General suggesting that he was ready to pay was on the 27th of the same month. How do you explain that?
Okay, it's very simple. Okay, and I said on the morning show that we had prior discussions with his lawyers. Immediately the order was served on him, his lawyers contacted us. Okay, so we had prior discussions, and based upon the prior discussions, we had decided that we were going to discontinue with liberty to come back if he did not fulfill his promises to us this time. Okay, and we prepared the documents, you know, and you will understand as a lawyer that when you prepare the document in chambers, you did the document on the day that you have prepared it, you have finalized it in chambers. So we said dated at the Attorney General's chambers, Accra, this 26th day of October 2016. That is the date that we dated the document. Now, the following day, we get Woyome's lawyer's letter. That is the 27th. All right? That confirmed the fact that he was serious about payment. And we went ahead and filed the notice of discontinuance. If you look at the court file, it is on the 31st of October 2016. Okay? This is it. For the stamped portion is what shows.
Let me highlight it. You can bring the camera on it. The 31st, which is here, written in red ink. So that is when it was taken to the court, and when the court wrote that this thing had been brought to its attention. So the date you went to seek to discontinue was on the 31st.
Was on the 31st, and it was after we received the letter. And we had further conversations with his lawyers. We met, as he himself said, during the press conference.
Shouldn't you have received the letter before preparing this document in the first place?
There's something. You know how we practice law. You talk with the lawyers. You understand that this is what the position that they want you to take. You start preparing. Okay, and you do it in good faith. And I'm telling you that the Attorney General would have insisted if Woyome's lawyers had not brought that letter, and if they had not confirmed that they were really serious this time, the Attorney General would have insisted that we should go ahead and not discontinue.
Okay, thank you. Now, Nana Kumia's question should be the one that we end with you, and then hear everybody else. Nana Kumia's question is that
it's all well and good. He's spoken to all the issues. Basically.
Why are we still talking about 51 million, 51.2? Because it's been a long time, and interest ought to have accrued.
That is true. I think, if I remember distinctly, when the court ordered that he should pay the money, the court did not say that he should pay it with interest.
Okay.
All right. So once the court did not order that he should pay it with interest, we took the view that it was only the 51 million that was due and owe him from Alfred Woyome.
And you still take that view?
I think I need to refresh my memory on that, because I think Martin went back. He went back to court at some point in time regarding this interest.
The same Martin.
The same Martin went back to court.
Okay.
He brought
because
an application
Professor
on
Kukwasari refers you to Rule 2.1 of CI 52.
Right.
Which says, quote, subject to sub-rule 2, each judgment debt shall bear interest at the statutory interest rate from the date of delivery of the judgment up to the date of final payment, unquote. And he says, if you take this and you look at the case which he refers to, Nova Complex versus Ghana Ports and Harbors, he says, without the court making the explicit order, he still ought to be paying interest.
That's the correct position of the law.
Okay, so actually,
it's the correct position of the law.
So actually, we are not looking at only 51.2.
But you also realize that it's simple interest, not compound interest.
Okay.
Yes.
Yeah, because I'm asking that also because you are now paying your attention to that.
Drawing my attention.
Yes. And then Woyome too, when he wrote to you, clearly is under the impression that he's paying only 51. He's paying only 51. So he says that he intends to pay 4 million. 4 million every 4 months. I'm looking for that attachment. That if you have it, I just wanted to be sure whether he said 4 months or 3 months. Yes, he says he wants to pay 5 million every 4 months, commencing the 1st of April 2017, and thereafter to pay all outstanding balance by 31st of March 2019. And as far as he knows, he's paying 51.2.
Well, they say a bird in hand is worth two in the bush. So let us secure the 51 million.
Okay.
Discussions can always be had about the interest to be paid.
Okay, but you pursue the interest.
Yeah.
You pursue the interest.
It's a matter of law.
Exactly. Yeah.
It's a matter of law.
Okay.
Let us have the 51.
Okay.
Let us have the 51.
Kuku's excited about that because all along.
Yeah, because I didn't even know that the law
that
really could allow the state to pursue the interest. I didn't know. I thought it was case closed.
Right.
So
Because it was not ordered by the court.
Yes.
Okay.
I was totally.
Right. Now, what do you say about that? Because that's your interest.
But the application to the court should have come with the interest. It's normal for him to pay the money.
He says we are drawing his attention to this now, and they will pursue it.
So,
well, I say let's get a 51 million, and then we can talk about interest.
I'm still unconvinced about the monies that went to Yoko.
Okay.
I'm still unconvinced. I mean, how payments are made into the consolidated fund, I think is driven by law. The Article 176 and the Financial Administration Act. I don't see why, and this Yoko Act, I've gone through it. I don't see anywhere that
the money that they realize through this law is shared afterwards.
But what they are doing now,
it will eventually it will be it will go into the consolidated fund. And you know that every agency of government has a sub account that is tied to the consolidated
this thing about sending the 4 million to an exhibit account.
If I may come in,
there are messages that have been sent, and I want to. I think I should give you.
But
it's.
I mean, he's dealt substantially.
Exactly, and
I would only
you can't do it as competently as he would do. So you do some 2 minutes, and let me take some text messages.
You see, the fact is that I do not see what the problem is really with what account the money is paid into. Ultimately, we are interested in getting money that has been paid unlawfully or wrongly to an individual. Now, that Ioko account is essentially a government of Ghana account. Any day that the government needs the money, we can retrieve it. So those who are now making the case as to which account the money was paid into appear to be shifting the goalpost. The same people who said they were interested, the same people who had tongue-lashed government, the government was not interested in collecting the money, are now raising issue with the fact that money has actually been paid, except that it's not in the AG's account, it's in Yoko's account. That money, but the point is that the money, but the money doesn't belong to Yoko.
It's not tidy.
The money doesn't belong to. He's explained to you why they are unwilling to pay it into the AG's account. In any event, if it goes into the AG's account, it's still government of Ghana money.
Okay.
When government needs it, it will lay hands on that particular money.
But so I almost forgot this. You said that because of the interpleader actions that came with regards to the real property, the houses, it sort of stopped you. But should it? Because if UT has an interest in it, you can still sell the property. UT takes its half, then you take what should belong to the state.
It depends on the extent of their interest. For instance, if he owes UT as much as he owes the government of Ghana, I don't think that there's any house in Trasaco. There are 2 houses that were, the subject matter of.
And there was the quarry too in the Volta region, is it?
Yes, the quarry in the Volta region. So these 2 houses together, I do not think will even satisfy the judgment that he owes the Republic. And I believe that No,
I'm not talking about satisfying the judgment that he owes the Republic.
Yes.
What he owes UT, you are still able to proceed, and then if he owes UT, if the properties together will go for, say, $100 million, $100,000, and then, he owes UT 50,000. You pay 50 and you take 50, you keep. That's what it's supposed to be.
Well, okay. I don't have the document here with respect to the interest of UT and how much it is. Okay. I can supply that information to you later.
All right, let me share some of the messages that have come in with you. Kwabena Odro Kwating in Albany, New York says that it's amazing how such a very private individual as Woyome is all of a sudden holding press conferences back to back. Why is he struggling so hard over a simple court deposition? Akwesi Champong in Maryland and the US says, if indeed Woyome used part of this money to pay Later Brew Law Company's client debt as he posited, then we have a big problem. Is that why we are being fed with this kind of Anansi portion by the Attorney General? Musa Bato in Kumasi says, the record of President Mohammed's government in preventing and fighting judgment death is very intense. Millions of dollars have been saved over the last 4 years. Is Martin Amidu fighting Woyome or judgment debts? Why is he not retrieving drill ship money? From Atta.
What money is that?
Well, of course.
Well,
the MVP.
from Atta Imoro in Wellensi, he says, what makes Ghanaians not to believe government is that government claims it is working hard to retrieve our stolen money. Yet, when Amidu makes similar efforts to facilitate the retrieval of the money, they are on the other side fighting him. Okay,
that is a problem. There's simplistic, uninformed commentary around the matter.
And this is part of what you hear spokesperson for spokespersons of the NDC and also even Woyome have problem. They say when you say stolen money and fraudulent money, blah blah, you are wrong. In fact, when he sought to speak to me, he was asking some of these questions. Well, I demanded of him to prove one single occasion where I was not fair to him, and he didn't give me any example, so I ended the discussion there. Michael.
The government itself accused Woyome of fraud.
Yes, they went to court, in the commercial court, as accusing him of fraud. In fact, they also went to the criminal process, except that was not successful. Michael Amening in the UK says, Woyome should spare our ears of his explanations because Ghanaians are discerning, and he will not earn the sympathy of Ghanaians. So he should go and face Martin Amidu and open the Pandora's box for the whole world to know all those who benefited from his ill-gotten money. I'll return to Kweku briefly on that issue because Woyome has an issue with Kweku too, because it does appear Kweku is suggested somewhere that he's going to disclose something. Paul Addo from Etibia in Kwehu says, please make the Deputy Attorney General understand that we, the people on the street, had one language, and that is what Mr. Amidu has buttressed. Vote Mahama out before we can take our money from Woyome, unquote. It seems the NDC have no political will in retrieving our money for us. I guess the create, loot, and share business is lucrative. Nana Akwesi Asafoe in Kwadaso says, in all this saga and the excruciating posture of the Attorney General as the principal legal advisor, my defense in all of this will be Article 41F of the Constitution. Ghanaians need to punish the government to save ourselves. Article 41F is about citizens having the right to, or a duty to protect state
that is political
public property. Well, as you know, it doesn't seem that it applies across board because some people went to court over the ECG privatization on courts, and they were told that they don't have capacity because it will not affect them directly. They have no interest. Well, Sofo Yamusa in Kombongo says that chronological events in respect of Woyome Saga is a clear indication that the John Mahama-led NDC government will not and does not intend to retrieve the unconstitutional payments to Woyome insofar as NDC remain in power. As the Citizen Vigilante says, the only way to retrieve the whopping 51 million Ghana cedis is to change. Then I think I can read a last one from Obeng Amunti in Achim Akroso. He says it is very funny and mind-boggling how the NDC government is handling the Woyome case. The integrity of the Mahama government is on the line. Posterity will never and ever forgive them if they treat this case with kid gloves. Thank you. We take a break. When we return, there's just a 5 minutes closure on it, and then we'll move on to the quote-unquote clash that happened at Nanado's residence and the issues that have also come as far as elections are concerned. We'll be right back. this is how we want to wrap up on this issue, and let's keep to it. 2 minutes. You don't do more than that. And I start with Kweku on this. Finally, you are very expectant of the 24th for the cross-examination. There are people who are suggesting that from the way things appear, it will not happen. It won't come on.
Well, with the assurance from the Deputy Attorney General that they are not thinking of any review, I'm beginning to think that it might come on.
Okay.
Because I heard in the grapevine that a review of a sort could, be thrown in there. That could have delayed.
Women's lawyers are entitled to do that.
Yes. Wow, that's true. I'd forgotten for a moment. And the way Mr. Woyome is talking, if I get his drift, because he's talking of fighting the thing, and so it's possible, then that means that we'll have delays. 24th November may not be the day.
Says he will do it with the last drop of his blood.
Yes, perhaps to postpone it beyond the elections, after elections, so that we'll continue. I suspect.
But you have been associated with a list of beneficiaries, and he's been talking, and he mentions even somebody in the MPP. He says, look, Obiamwa worked for me. I paid him money out of this. So what would you say about that?
That's what he's saying.
Yes.
Yes, and he will provide evidence to show what work Obiamwa did for him, which I think was in the public domain some time ago. If you recall, when the police CID went arresting Obiamwa and charged him with some bogus thing about corruption of public official. These are the Obiamwa documentations. These are the things Obiamwa did for him. It's about some land. So, as well, when he sees that list, to be honest with you, it is only in a court of law that I think that list will have value. That could be subjected to proper examination.
We are told you have been waving it around town, and that's made you even dance the more.
I have a list, and indeed I have called 2 of the people on the list, and they have confirmed receipt of those monies attached to their names. I have it.
A list of beneficiaries.
How
do you know that it is out of that money that they were paid?
The monies were paid to ADB, isn't it? Okay. That's a clue for you.
I see.
So that when you see check starts, what do you call those things? Me, I don't know much. I don't do financial engineering. So if you can help me, when you sign a check,
the stop. That's what it's called.
I don't do financial engineering.
I see.
So you see, it is only in a court of law that you produce such a document. You don't wave it around. Post-court, yes, it will be for the public opinion also to examine.
Okay. Thank you. Yes, Felix.
That's one last point.
Yes, sir.
You see, did I hear Mr. Woyome suggest that at a certain stage Martin wanted to be made a president? Constitutional absurdity. How is that going to be possible?
He actually said Martin attempted to beat Professor Mills.
Yeah, but the point about him seeking to be made president is an absurdity constitutionally. That should tell you who is telling the truth and who is just throwing out lies.
Okay.
Tell Mr. Woyome to shut up.
He says, and again, Woyome says that Martin Amidu was dismissed because he had alleged that he knew of corrupt people in the government. Professor Mills asked him to submit a list within 7 days. He didn't produce the list, and that's why he was booted out.
In fact, you recall, I don't know whether you hosted the program that day. I was the first to call for his dismissal for that outrageous conduct. There was no way that his position as Attorney General was any longer tenable the day that he went to town in that particular episode. So any president with a sword would have dismissed him anyway. Therefore, what Mr. Woyome says, Mr. Woyome is not the most...
Is it really the case that he had not been able to submit a list?
Oh yes, but he was actually called to the council for a meeting. There's actually a letter.
Yeah, but he had also written a letter or a press statement when he was issuing his epistle.
There's a letter.
Showing clearly that he had done that.
Chikata and Alaji Bruce Mahama entreated him to write that letter of apology, which he did.
There's no record of that. What is on record is a letter in his own handwriting, bearing his signature, in which he apologizes for misconduct before the president of Ghana. But I'm saying that misconduct is notwithstanding. If I am president and any cabinet minister does what Martin Amidu did when he wrote that epistle, I will dismiss him. It's a matter of principle. But the point I want to make finally is that the Deputy Attorney General, in my view, has dealt with this matter in a comprehensive manner. Anybody interested in facts and not prejudiced by political coloration and an effort to dabble in propaganda would appreciate that the Attorney General has done what is humanly possible to retrieve this money. Those who go about claiming that not enough has been done appear not to be speaking on the basis of facts. And I'm disappointed in the lives of Suleiman Abraham and Manasseh, who, without basis, without having averred their minds to the facts, make sweeping, sometimes uninformed commentary about the matter. You see?
Insufficient.
No, but on what basis do you determine insufficiency? The Attorney General has told you about Ganishi orders that
let's not go back there.
She has told you about property.
Well, they agree with some of the comments of the
so
court.
let them offer.
They are not alone.
Let them offer alternative arrangements that the Attorney General could have entered into. That she has not. In any event, the application to orally examine Woyome was brought by the Attorney General. Amidu merely inserted himself in the matter. The application to orally examine Woyome, which they discontinued. Liberty to reappear was brought first by the Attorney General, not at the prompting of Martin Amidu.
Yes, like Felix says, are you convinced now beyond doubt that you shouldn't put any blame at the doorstep of the Attorney General in the attempts to retrieve the money?
This is the Attorney General who's been touted by the President as having such a wonderful record
because he saved
in dealing with judgment debts.
So about $1 billion, Ghana cedis.
Yeah, it's a fact.
$1 billion.
It's a fact, yeah.
Oh, but we haven't gone to check what the other Attorney Generals also saved the country of.
They fought and won.
So I think
they are free. They are free. Well, they are also there's also the case of the
let's not go there. Let's not go there because we are just trying to check what any Attorney General did. So
the Attorney General did not go to court and we lost. We had default judgment
against
India.
Sorry.
In fact,
every Attorney General has had to deal with judgment debts. They have saved the country. Let's go.
What happened?
Attorney General. Yes.
To come to your turn.
Okay, yeah.
I'm saying that this Attorney General who's been touted as having such a good record is very strange that in this particular issue of Woyome, how many years we haven't retrieved?
2 years.
We started fighting this case way back. We haven't retrieved anything. The public perception out there is that this is a collusion and all of these things that have been done that Mr. Ayeni has told us about. It's just going through the motions. And for a lot of us, this is our view. And so I agree entirely with Mr. Martin Amidu, and I'll just quote him to end. And he goes, I am a senior and foundation member of the NDC, the governing party.
By the way, that was a sponge. That was a sponge. It's one of the paragraphs.
No, this is a statement he put out.
This is a statement he put out. I'm reading his statement.
Well, it's
sorry.
in the public domain.
It's partisan propaganda.
Sorry. Thank you.
But you will not be the first person to
Sorry.
Woyome is now partisan. Where was Woyome?
Okay, the protocol is that when I start speaking, you stop. Okay, thank you.
Protocol respected.
I agree. You see, this comment by Martin Amidu captures the public mood. That's why I want to read it.
Quickly.
I am a senior and foundation member of the NDC, the governing party, but I'm compelled to put Ghana first and to defend the 1992 constitution by saying that the only way Ghanaians can have these Woyome Austro Invest joint loot refunded is to change the government that created, looted, and shared the loot with them during the presidential elections this year. Even though I'm a lawyer member of the governing NDC, I cannot in good conscience and in defense of the constitution support his presidential candidate to continue leading the looting of the public purse. Mr. Martin Amidu is calling for the rejection of his own party based on this way.
Okay. Points made.
Yes.
Thank you. Thank you. Yes, Doc. Doc, you wrap it up for us.
All right. Thank you very much, Samson. You know, for some reason, this public's perception and the portion that he has read persists in spite of the fact that we have put out all the facts about what we have done. And I want to...
And you haven't been successful.
We have been successful. At least we have, the 4 million has cleared. 4 million out of the 51 million plus interest.
Some people are angered at the sound of that. So can we just move on? Sorry. Yeah.
Yes.
And how so?
And we have
the chronology of events.
We have
their minds with the facts.
We should actually clap
and
for
cut
you.
out the emotion. Nobody has called for praise
guys.
or clap.
Okay, guys. Thanks.
We must
Felix,
stick to the facts.
Thanks.
Okay, so I need to underscore one thing quickly.
Yeah.
If you look at the parties to the suit, Austro Invest was not a party. to the suit.
No, they were taken out earlier. They were struck down.
They were
apparently went bankrupt and liquidated. Even that was weird, the way it was done.
Martin says it was joint.
Yes.
Payment, joint liability.
Look,
so
there was
speak.
close collaboration between Woyome and Austro Invest. They were in conspiracy together.
On the record, they were not a party to this. I mean,
struck out earlier.
And it has been documented, very well documented, that the Attorney General never represented Woyome. I want to make that patently clear. At this point in time,
their clients were in collaboration.
That's we are all interested. Okay, and I say as Ghanaians, we are all interested in the recovery of this money. We have worked zealously, even though others think that we have been lax. We have worked assiduously.
They measure your work by the results.
Well, I don't know whether even as lawyers, people like Isan Kuma would have done better in terms of the recovery. Okay, we have all done debt recovery before as lawyers, and we know how difficult it is. In private practice. So,
Supreme Court judges are saying the same.
Yes,
Supreme Court judges are saying the same.
Sorry, don't do that. And do it quickly.
It's true.
Quickly, and let's move on. Okay, thank you.
But I also
disagreement with the Supreme Court judges.
I have also alluded to the practical difficulties that may attend whatever is going to be done on the 24th. Right. So you ask yourself, after the oral examination, what next? He would have obtained information, but eventually, if you look at the judge's order, right, it is limited only to the oral examination. It hasn't said that Martin Amidu can then go ahead and issue a FIFA out of the court to attach properties. It hasn't said that he has got the power, to apply for Ganashi orders under, Order 46 of the High Court Civil Procedure, Civil Procedure Rules. Okay, so it means that ultimately, the same reluctant Attorney General that he's accusing of not taking steps will be the person who will have to take those steps after he has obtained the information. Yeah. And then more importantly...
Did he have to say that? Because he said that, I am prepared to offer an opportunity to the plaintiff applicant, that's Amidu,
yes,
to proceed accordingly to execute the judgment as a party who initiated the action for the benefit of all the citizens of Ghana.
Well, but you see, he is basing this on Article 2, okay? But we made arguments with respect to Order 46 of the High Court Civil Procedure Rules that technically Martin Amidu doesn't qualify as a judgment creditor for purposes of enforcement. Okay. The judge should have dealt with that. He did not. Okay, that raises another, a practical difficulty when we come to the execution. So finally, I'm not fighting Amidu.
That is
okay.
Okay. But one of the practical difficulties, even in respect of the oral examination, is that if you look at Article 19 of the Constitution, okay, Martin Amidu, Woyome, could, if what my brother Kokubako is saying is true, okay, there will be criminal implications if what you are alleging is true, right? He could then trigger an Article, a 19 right to remain silent in court. Just think about that. And no court can.
Yes, to be silent.
He can do that.
Martin,
and no one can
compel. And you be silent.
Yes.
Okay.
And no one can compel him.
The
documentations will be put in his face. The documentations, like Oku is saying, they have them. So the evidence will be put in his face and they will be put to him.
Which documentation?
About the disbursement of the funds.
But you would have to establish a relevant.
Are you interested in the disbursement or the sources of assets for purposes of recovery? But how does that help you?
But in the same vein, you went and you were going for this process.
Yes. What were you going to do?
Are you saying that you were also going to face a similar situation? No, in the same way, Woyome could have exercised, like he said, to be silent and not to speak.
But at least the process would have been undertaken.
But something, you saw the list of questions that we said we were going to ask him. It didn't include list of beneficiaries.
Yeah. Okay.
Which for me is completely irrelevant.
All right. Sorry.
Totally.
Thank you.
Really?
Thank you very much, gentlemen. Thank you very much, gentlemen. Shall we now do this? Okay. Thank you very much.
We've moved on.
And then I think sometime in August 16, 2011. I did a story from the court on the payments, and I just want, for those who are looking for the history of this case, you can be following up. Go to type in AG paid 42 million to NDC Guru in disregard of a court order to pay 17 million, and you see some of the history of it. Just Google that and something might come up for you. And then also, more importantly, I did this article giving the Dateline facts file plus 5 key questions. So you just type in Woyome 51 million payment, Dateline fact file plus 5 questions. And you will know from day 1 of the contract, before the contract, after the contract, how he went back, how he got the money, and the processes of payment up to the end. I put a Dateline to it. So just type in Woyome 51 million payment, Dateline fact file plus 5 questions. I did that also sometime long ago. Thank you very much.